Legal comedy courtroom satire scene 1, news desk cold open, 60 seconds. Anchor 1, in 2019, Theodore Crescent filed a patent claiming ownership of the sun. The actual sun. Anchor 2, and the USPTO accepted it for review. Anchor 1, someone looked at "I own the sun" and thought, this warrants examination. Anchor 2, there were depositions. Expert witnesses. A class action representing all of humanity, past, present, and future. Anchor 1, the unsealed documents reveal, well, you'll see. Scene 2, Theodore's office, 90 seconds. Theodore, reading application, Sol, a G-type main sequence star. Applicant claims prior discovery, as no other human has filed a competing claim. Assistant, the sun is 4.6 billion years old. Theodore, and nobody's claimed it. That's prior art abandonment. Assistant, that's not what that means. Theodore, I checked. No existing patent on the sun. Assistant, because you can't patent naturally occurring phenomena. Theodore, Diamond vs. Chakrabarti, 1980. You can patent natural things if you've isolated them. Assistant, you didn't isolate the sun. Theodore, I isolated the concept. I'm the first to recognize it as intellectual property. That's innovation. Assistant, that's insane. Theodore, file it. Scene 3, USPTO office, 75 seconds. Examiner 1, Bob, I got an application for the sun. Examiner 2, solar panel. Examiner 1, no, the actual star. Exclusive rights to all energy output and gravitational effects. Examiner 2, pause, what's the grounds for rejection? Examiner 1, that it's the sun. Examiner 2, is there a statute saying you can't patent celestial bodies? Examiner 1, I've never had to look. Examiner 2, then process it. Examiner 1, this is going to be a nightmare. Examiner 2, not your problem. You just accepted a patent for the sun. Examiner 1, I need a drink. Examiner 2, you need a new career. Scene 4, deposition highlights, 90 seconds. Lawyer, you're claiming you invented the sun. Theodore, no, I discovered it as intellectual property. Everyone knows penicillin exists. Fleming still got the patent. Lawyer, Fleming isolated penicillin in a lab. You didn't isolate the sun. Theodore, I isolated the legal concept of the sun as property. That's a novel process. Lawyer, you invented the idea of owning the sun. Theodore, yes. And ideas are patentable. Lawyer, no, they're not. Processes are. Products are. Ideas are not. Theodore, then I'm patenting the process of claiming ownership. Lawyer, that's circular reasoning. Theodore, that's innovation. Later, lawyer, 4.6 billion years of existence isn't prior art. Theodore, existence isn't intellectual property. Ancient Egyptians worshipped Ra. Did Ra file a patent? No. Did Egypt? No, I did. First to file wins. Lawyer, that's not how this works. Theodore, then why did the USPTO accept it? Lawyer, pause, I don't have a good answer for that. Scene 5, courtroom expert witnesses, 90 seconds. Dr. Voss, astrophysicist, the sun is a celestial body. It can't be owned. Theodore's lawyer, the Outer Space Treaty prohibits nations from claiming celestial bodies. Nothing about individuals. Judge, is that true? Plaintiff's attorney, technically yes, but Theodore's lawyer, no law prevents my client from claiming the sun. Dr. Voss, there's also no law preventing me from claiming the color blue. Theodore's lawyer, Tiffany & Company trademarked a specific shade of blue. Dr. Voss, that's a trademark. Theodore's lawyer, semantics. Later IP lawyer testifies, sure, he's exploited every loophole in patent law. Technically, there's no statute prohibiting this. Judge, so it could be valid? Sure, absolutely not. but proving why requires arguing principles so fundamental they've never been codified. Theodore's lawyer, so my client is a pioneer. Sure, your client found a gap in the law the size of the sun. Literally. Theodore, standing, the sun is a product. This is America. Judge, bailiff. Scene 6, Theodore's testimony, 75 seconds, plaintiff's attorney, if you own the sun, are you liable for sunburns? Skin cancer? Droughts? Theodore, I'm claiming the energy output, not the side effects. Plaintiff's attorney, you can't have it both ways. If you own the product, you own the consequences. Theodore, I'm licensing the beneficial aspects. The harmful aspects are acts of God. Plaintiff's attorney, you just said you own the sun. Now it's God's. Theodore, I own the intellectual property. God owns the operational liability. Plaintiff's attorney, that's not a legal distinction. Theodore, it is now. Judge, you're contradicting yourself. Theodore, I'm innovating. Later, Theodore, the sun has 100% market penetration. That's the dream of every business. Lawyer, you didn't create the distribution network. Theodore, Amazon didn't invent roads but they use them. Same principle. Lawyer, that's, you know what? I'm done. Theodore, let the record show the attorney has conceded. Lawyer, I haven't conceded. I need a minute. Scene 7, final ruling, 60 seconds, Judge, Mr. Crescent's patent is invalid. The sun is not a human invention and cannot be owned. Theodore, but the Outer Space Treaty, Judge, the spirit of the law extends to individuals. Theodore, spirit isn't the same as letter. Judge, you're not getting the sun. Theodore, standing, the sun never sets on innovation. Judge, bailiff, remove him. Scene 8, news desk close, 60 seconds, Anchor 1, Theodore Crescent's appeal was denied in 2022. Anchor 2, he's currently working on a patent for the moon. Anchor 1, the moon. Anchor 2, Earth's natural satellite and orbital asset. In a statement, he said, I've learned from my mistakes. You can't eat the sun in one bite, I should have started smaller. Anchor 1, that's not the lesson. Anchor 2, it is for him. Both, good night. Some things are too vast to govern. But that won't stop people from trying. Text on screen, Theodore Crescent's moon patent is pending. The USPTO requested proof of prior discovery. He submitted a 47-page document titled Lunar Licensing, a framework for orbital asset management. We're all doomed.